where from the tribunal gets the powers for life time disqualification?
It has declared.
No, where from gets the powers to declare him
Has
for
declared
life?
a decree given remains intact for all purposes.
Next point.
No, this argument basically it lies in Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is, wherever mens rea is dishonesty, we are talking about public office holder.
You just very casually referred to Islam. Either back it up, because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam, and then they became Khalifs, Khulfa Rashideen. तो वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है. शुरू में तो 2-4 ही मुसलमान थे. तो ये आप ऐसे just don't throw in Islam to give it a validity.
No, my lord. What I am submitting is, if repentance or tawbah, when we look at
repentance और तौबा की तो बात से आगे मैं चला गया हूँ.
That's what I am submitting. These are 3 things kept by God to Himself. Number 1,
not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No submission. You refer to the Holy Quran. You can't just make a submissions contrary to Islamic principles like this. ऐसे नहीं होगा.
But I change the subject a little. Let me just introduce one other aspect. Let's stay on 62(1)(f). If we look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all. This is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification under declaration of contrary under some law. And if the law Parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the Parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law. And law has been corrected and given a period. So there's a distinction. Had there been a constitutional provision, disqualification like age being 25, then perhaps, to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on the validity of the law. That's why I tried to argue that under what proceedings we are before my lordships. I rely on PLD 2012 Supreme Court 923, Baz Muhammad Kakar Federation of Pakistan. It is the case where Contempt of Court Act 2012.
आपने सारा आर्गुमेंट सुना हुआ है, proposition बता देना please.
My proposition is through ordinary law, Parliament cannot amend the constitution.
No, fair enough.
It has not amended the
That's what I'm trying to tell
They
you.
have added in the constitution, because how do I demonstrate that
whether the court can amend the constitution,
court can interpret it?
interpret in a manner to amend the constitution or to
No, my
read
lord.
into the constitution.
No, my lord.
So this is what we are asking from you, whether the interpretation can be done. देखिए इसमें एक बात आप ये आप कह रहे हैं 62(1)(f) में ये बताया गया है कि डिक्लेरेशन होनी चाहिए कोर्ट से, और आपने कहा कि डिक्लेरेशन सिर्फ ट्राइब्यूनल दे सकता है। ट्राइब्यूनल अंडर सेक्शन 157 वो ग्राउंड्स बताए गए, ठीक? क्या उन ग्राउंड्स में ये बात है कि ट्राइब्यूनल इस बात पे आपको डिस्क्वालीफाई कर सकता है कि आप राइटियस नहीं हो, आपको सजेस्ट नहीं हो, आप अमीन नहीं हो, आप सादिक नहीं हो? ऐसी डिक्लेरेशन आएगी तो 162(1)(f) इस्तेमाल होगा, अदरवाइज नहीं होगा।
That's what I'm saying. That in my case, FA degree was forged, BA degree was forged, trial
क्या आप हमें
डिक्लेरेशन कहाँ से आया आपके केस में?
election tribunal.
देखिए खुरम साहब, एक चीज है, देखिए, स्पीकिंग फॉर माई सेल्फ, देयर इज नो कंफ्यूजन इन माई माइंड दैट to set aside a judgment, the premises on which that judgment stands needs to be taken away. So if the judgment stands on a law, then there could be an amendment in the law, and that foundation of that judgment on which it stands is taken away, and that judgment is nullified. If the judgment stands on the constitution, constitutional amendment is required to take care of. There's no, as far as I'm concerned, no. I'm saying in this particular case, 62(1)(f) is not a disqualification. The judgment does not stand on 62(1)(f) as such. It stands on a declaration by a court of law.
My lord.
That declaration is not done through constitution. That declaration must be of based on some law. That law now provides a period of 5 years for such declarations. Hence, that premise, that declaration that's coming out of a law has been given a period. So wo khatam ho jati baat, 5 years then plugs that problem.
Election tribunal has to determine on the basis of qualification, disqualification given in Election Act as well as 62-63. Why I am saying is I have also appended parliamentary debate from Senate on the amendment. It's at page 28. They have admitted it's silent. Once they have admitted it's silent, the only requirement...
What do you mean it is admitted is silent? What does this mean?
I mean, in parliamentary debate, which we can look into to see.
So why don't you look at the constitution itself? I don't know. देखिए ये from Hebdo. Do you know what Hebdo was?
My lord.
One dictator.
My lord.
Throwing out everybody.
My lord.
Followed by another dictator. Throwing out everybody. Following by a third dictator. Throwing out everybody. Are you forgetting all these things? No, please, एक second ठहरिए ना. The constitution, original constitution did not have these D, E, F, G clauses.
My lord.
These are imposed by a dictator, correct or not correct?
Correct.
Why you gave it no importance? Either say we support dictatorships. Hang on, ऐसे नहीं होगा ना. We can, जरा बात तो सुन लेना. आइन का तकद्दुस उसी वक्त होगा जब हम उसका तकद्दुस मानेंगे, या हम कहते हैं हम बंदूक का तकद्दुस मानते हैं। जब पार्लियामेंट में जो 326 लोग बैठ करके कानून साजी कर रहे हैं, जो आप 326 से पहले कम होते थे, वो एक कानून साजी कर लें, और उन्होंने ये किताब हमको बना के दे दी, और फिर एक शख्स टहलते हुए आते हैं, वो कहते हैं बाहर जाए कॉन्स्टिट्यूशन मैंने एब्डो कर दिया।